Cheatham, are you guys ready?
Yes, Your Honor.
Okay. If you are the victim of a crime with a case pending before this court, you are advised to have rights under Arizona law that, among others, include the right to be treated with fairness, respect, and dignity, to a speedy trial, to be present at court proceedings, to choose whether or not to be interviewed by the defendant or the defendant's attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling and sentencing, and to receive restitution from a person who is convicted of causing your loss. If you have not already been provided with written statement of all victim rights, please contact the Victim Service Division or the Prosecutor's Office. Number 3, time set for a pretrial conference, State v. Martin Hassett, CR 2015-127-004. Appearances, please.
Doug Self on behalf of Gina Cucuzella for the state.
Good morning, Your Honor. Tamika Tim on behalf of Martin Hassett, who's not present.
Have you heard from him?
No, Your Honor, the state has a motion.
Oh.
Your Honor, the state had recently learned the defendant was deceased. Ms. Cucuzella has a motion to dismiss with a proposed order of background.
Okay. Based upon the written motion, the court will grant the motion to dismiss. If the presumption is overcome, it will be dismissed with prejudice. I believe he had been on pretrial services, so that we don't need to exonerate any bond.
He was, yeah. Just in case.
I'll give you paperwork. We can give you one, but I don't think anybody will give you any money.
Okay, then that's fine. We don't need it.
I'll exonerate a bond, but I don't think anyone was supposed to.
Okay.
Thank you.
Jack.
Ducks. I don't know what that means.
You know that we didn't take out yesterday after pickup? We put her everywhere.
And Ms. Cheatham, I'm sorry I didn't know the circumstances.
Oh, no problem. Have a good day, Your Honor.
What's that, man? You gonna use the podium? No. All right, here we go.
To the podium. All right, ready? Are we ready? This is number 4, time set for a case management conference, State versus Leslie Merritt, CR 2015-144-211. Appearances, please.
Good morning, Your Honor. Vanessa Losico on behalf of the state, along with Ed Leiter.
Good morning.
Good morning, Your Honor. Jason Lamb on behalf of Mr. Merritt. He is standing to my left. He's in custody this morning.
Good morning. The motion for camera coverage is granted. I read some pleadings. Have the parties discussed scheduling on any of them?
Yes, Your Honor. We picked the date of April 29th at 1:30.
To hear which motions?
The motions with respect to Ms. Foster.
Okay. Has there been a decision made on any Cronus hearing?
We can handle that at that same time as well, Your Honor.
Okay. And then, Mr. Lamb, with respect to your motion with, on the Rule 15 issue, for the peer review, the notes for the peer review.
Yes, Your Honor.
Are you prepared to do anything with that today?
I am prepared to argue that to the court. I believe we filed it in the context of a motion to compel.
Let me ask this question.
Yes.
I have an expert that's going to talk about the alphabet, and it's their policy to have it before John Smith testifies. They have it peer reviewed. So he shows it to Mary Brown, and Mary Brown says, "You forgot the O, and you should put a tilde in there." And so he looks at the report and says, "Oh, I did forget the O, but we don't need a tilde." And then he supplements, or when the final report comes out, it has the A through Z alphabet. And he testifies. And he testifies that part of his testimony came from the fact that he talked to Mary Brown and it was peer-reviewed, and this is his opinion. Why do you think it's relevant that he had any discussion with Mary Brown, and what if Mary Brown wrote a note or had a discussion with him and he changed his report?
Your Honor, if it were only so simple as a missing letter of an alphabet or a tilde or an accent, this is an instance where we had an FBI agent in the Phoenix office handling the GPS coordinates associated with Mr. Merritt's phone, other phones, and cell tower dumps. What he did is he had to send it to another agent in Baltimore. The Phoenix agent is relatively junior to this particular specialized team that the FBI uses on a national basis. In fact, the draft report was prepared approximately September 22nd and the final some 3 months later. But there were substantive changes. Substantive changes, not just making things look pretty, if you would, not just changing formats around. And these are matters that perhaps I should submit to the court under seal so the court can see some of the discrepancies and the distinctions.
Well, I'll accept that, but the witness that they're calling is going to come in and testify to the later report and adopt it as it being his work product and his opinion. And it sounds like you have him subjected to cross-examination to version A and version B. And if he was I don't want to demean him, he's a B student and they have an A student that they haven't called as a witness, I don't know what you get from interviewing the A student if they're calling the B student.
It's not so much that we want to interview the A student, or if you will, the FBI agent in Baltimore, but when it comes to the Phoenix agent, the methodology which he implemented to produce his report, it's relevant. It's relevant to impeach him as to any bias, as to any credentials that he may have. And there is one specific thing, and I realize it may play better to the court in writing, so you see the report. Within this mapping, if you would, there was a subjective box of an excerpt of a text message that I believe was from the 28th between Mr. Merritt and his father-in-law. And there was a reference to the father-in-law saying, "I'll show you my Glock." Now, the point of the matter is it's not Mr. Merritt saying, "I had a gun," and that's going to be the subject of the motion in limine. I'll file it under seal. I'll need to give you the attachments. But the question becomes, was he operating from an objective methodology with respect to the science that he was using to establish the GPS coordinates? When, another agent potentially is trying to influence that opinion and say, "Hey, I need you to pepper your opinion with this," and this is a more senior agent, I think it's relevant because it goes to the Phoenix agent's bias and his credibility, and all we're simply looking for is the notes, the emails that went back and forth.
Well, let me ask this. I don't have a full understanding. Do you have only the later report, and because of interviewing him, you know that there existed a earlier report, or do you have both reports?
I have both reports, Your Honor.
Okay.
The draft report was disclosed to us, I would say, fairly early on, and in fact, I'll tell the court, when we litigated the motion to modify release conditions on November 16th of last year, the court may recall a color map and some positions that were located. That was actually part of the draft report that had been given to us. So I would venture to say it was back in October we had the draft. It was only earlier in 2016, or perhaps the very end of December of last year, that we got the final report. And I believe there are some substantive differences. All we're trying to do is explore the notes and the factors that the expert relied upon. Just as we would with any other expert, we're entitled to their notes and other people that they talk to, data that they use for the formation of their opinion. That's what we're seeking.
Ms. Losico, was your office involved in any way in the formation of your expert witness's opinion, in terms of it sounded like there was a communication between Phoenix and Baltimore. Did your office have any input in that communication?
No, Your Honor. It is my understanding, based upon Agent Young's interview by Mr. Lamb, that he works on a nationwide team, essentially, and that's where his peer review goes. I mean, he is an FBI agent. They are national.
So it was their normal peer review process.
That's my understanding.
And you also, are you aware of Agent Young's notes being disclosed, his draft report and the final report?
His draft report and his final reports were disclosed.
Are you aware of any other statements that may fall within the definition of statement under Rule 15 that Agent Young has not disclosed?
Not to my knowledge.
Did you make that inquiry?
I will, Your Honor. Additionally, I do think it's important to let the court know that Mr. Lamb did, in fact, ask follow-up questions to Agent Young. We have provided answers to those questions. FBI Division Counsel here in Phoenix is apprised of this issue. They were made apprised of it when Agent Young went back to his field division and indicated that he was asked for these documents. Division Counsel has asserted their rights that they are not providing those. The state has not had an opportunity to respond to defense's motion. The statutory time has not run, and I know that Division Counsel intends to get back to me, at least, with their position. So if the court is inclined to grant the defendant's motion, I would ask that we at least be able to file our response to preserve the record.
Mr. Lamb.
Your Honor, the only point of clarification to make about the existence of the underlying documents, notes, emails, etc. When I interviewed Special Agent Young, he did confirm to me that there were emails that went back and forth. So by no means is this a fishing expedition. I was very direct and pointed in my questions about the existence of these underlying documents and communications. He did say that he was in possession or had constructive possession, at the very least, of these documents. I asked him about turning them over to Mr. Leiter, who was handling that interview. He did not have a problem. Respectfully, Mr. Leiter did not voice any objection at that point. And to the extent that the FBI objects, and they're asserting a right, as Ms. Lasico said, I don't know what right the FBI has per se, because under Carpenter, the FBI agent is an agent of the Maricopa County Attorney's Office. He falls within the definition, whether he is as post certified or whether he's Department of... We are not in federal court.
To that last part, trying to get in the battle with the feds, it's like we go a passive-aggressive attitude. The state calls a federal agent who's subject to the Rule 15 rules. But to that end, the state has listed only Agent Young as the witness, so it's his statements that are by Rule 15. And if someone writes a note and then it's incorporated in a final report, the note can lawfully be destroyed under Rule 15. So I would ask the state to inquire whether what has been disclosed by Agent Young, his draft report, his final report, whether that comprises all of other statements relevant to his testimony, and that they be disclosed either under 15.1 or 15.1G if they're going to assert that they're a third outside agency. But to the extent that there may be someone else who made statements who's not listed as a witness, the court just would not oblige disclosure.
And do I understand the court's order to mean that if there are emails, we are entitled to receive Special Agent Young's portion of the email chain, even if the Baltimore special agent's comments are redacted from disclosure.
Unless, he asked, what do you think about paragraph 4? And the answer gets, paragraph 4 is great. I mean, it's incorporated already in his report. So cops write notes all the time, and then they're incorporated into a final report, and they're lawfully able to destroy those notes, and they don't become the statement. So I don't know what we're talking about here. I don't know what these email chains are. I would oblige the state to inquire, and Mr. Agent Young to state truthfully that there is no statement relevant to the case that has not been incorporated in anything that they've given you. So, anything else for today? Oh, there had been, is there an agreement about the disclosure for your ballistics experts report, or at least the materials to go back so that the defense can make their independent inquiry?
Yes, Your Honor. The state has disclosed a written statement by Mr. Haig this morning, which is a PowerPoint that he prepared. His final report will not be done until on or before April 15th, and I believe that is suitable to the defense.
And in my mind, if he's working on the written portion of the report, if the physical evidence can be transferred separate from that, I don't know if he needs to look at everything before he puts everything in final written form, but the physical part of it can be started before he gets the final report.
And we have worked that out, and that's what has happened, Your Honor.
Okay. It may be redundant, but I'll order that the report be disclosed, or at least the materials be disclosed by April 15th.
And as the court's informally aware, once my expert gets the materials back, he will be able to complete and produce a report in about 30 days, but obviously he needs to have Mr. Haig's report to the extent that anything needs to be addressed. Of course, by making these representations to the court, by no way am I waiving any objections to the cumulative nature of Mr. Haig's testimony insofar as a DPS criminalist has already done the same or similar analysis. I'll preserve that objection to potentially litigate at a later date.
This is all on the level of relevant or may lead to relevant evidence, so I'm making no trial rulings today. Anything else for today, Ms. Losico?
Yeah.
Mr. Leo.
And Judge, for the record, we're doing our next case management conference at the same time as the evidentiary hearing on 4/29.
At 1:30. If anybody needs anything in the interim, just ask. Thank you. We are adjourned.
And what's the case management plan for the next hearing?
Fine.
Thank you, sir.
Thank you.
Good.